Good afternoon, everyone. I'd like to thank everyone on behalf of the organizing committee, especially the 16 teams that participated in today and yesterday and today's pre-moot, and the 60 arbitrators that dedicated some of their time over the weekend, and the 6 arbitrators that participated in today's semifinals. And I'd also like to express my sincere gratitude to Rafael Alves, Joaquim Muniz, and Professor Paula Costa Silva for presiding today's final. And we'd like to congratulate everyone on their excellent work in today's semifinal, especially Puck and Mackenzie with this traditional pre-moot in semifinal in São Paulo. And without further ado, Rafael, Joaquim, and Paula, the floor is yours.
Thank you. Hello, everyone. It's an honor to be here. I'd like to thank Souto Correa for organizing the first pre-moot in Brazil in the 11th edition. That's a history of success, and thank my co-arbitrators, Paula Costa Silva and Rafael Alves. Without further ado, I ask the teams if they have an agreement on the time allocation, who will go first.
Good afternoon, members of the Arbitration Tribunal. My name is Karina da Paz, and alongside my co-counsel, Mariana Carreira, we'll be representing claimant on today's proceedings. I'll be addressing the jurisdictional issues, while my co-counsel will be addressing the merits of this dispute. And regarding the time allocation, the parties agree that each party will have 14 minutes to make its submission, followed by 1 minute rebuttal and rebuttal. However, according to the order of these proceedings, claimant suggests that respondent start on both the jurisdictional issues, since it is the one that is contesting the jurisdiction of the arbitration tribunal, and in the merits of this dispute, since although claimant was the one that initiated this arbitration, it is respondent that is bringing the grounds for the exclusion of the CISG. And since in the present hearing we're merely discussing the applicable law to the substantive issues, it is more reasonable for both parties and this arbitral tribunal to first discuss whether respondent brings the grounds for the exclusion of the CISG, so claimant can respond accordingly without anticipating respondent's arguments.
Thank you. So I'd like to hear respondent counsel.
Respondent disagrees with this position because if the arbitral tribunal could please follow me to page 7, which is the request for relief for claimant.
Yeah.
It is a claimant's first claim that the agreement is governed by the CSG. And therefore, since claimant is bringing the application of the CSG in the present case, it must be claimant that addresses why the CSG would be applicable so that respondent can respond.
Thank you. The tribunal expected the discussion, this disagreement, and debated beforehand and came to the conclusion that as to the jurisdiction, there's an agreement here. Respondent go first, and on the merits, claimant goes first.
Perfect, thank you.
So respondent, have the floor for 14 minutes. Just let me know when you want to start.
Good afternoon, members of this tribunal, opposing counsels. My name is Maria Beatriz Ramos, and I represent respondent, Equatoriana Rent Power, on the procedural issues. Members of this tribunal, a successful relationship relies on commitment, but claimants show that for it, commitment was not important, as they refused to honor the agreement not only once, but twice. To demonstrate that, it is necessary to take a step back. Respondent, Equatoriana Rent Power, it's a full-on state company from Equatoriana that had a clear goal of decarbonizing its energy production until 2040. For that, they invited claimant, an engineering company from Mediterranean, to participate into a tender procurement process. Claimant offered the most competitive bid, and because of that, was awarded with the purchasing services agreement. However, the first show of lack of commitment of claimant relies here. Claimants never delivered the e-ammonia option, an option that was on the agreement, and delivered the project of the plant with a delay. Moreover, as it wasn't enough, claimant ignored the provision of the dispute resolution clause that the parties should refer the claim to mediation as a condition precedent to arbitration, Moreover, they submitted in this dispute Exhibit R3, Exhibit C7, that it's a document protected by without prejudice privilege, and they ordered this tribunal to exclude Exhibit R3, a document that is protected by attorney-client privilege. So, members of this tribunal, therefore, the respondent will make the following two submissions here. Firstly, that this appeal tribunal does not have jurisdiction to hear the case, as the arbitration agreement is not operative. And secondly, that Exhibit C7 should be excluded from the case files, and that Exhibit R3 should be maintained. Members of this tribunal, in relation to my first submission, this appeal tribunal has no jurisdiction to hear the case, as the arbitration agreement clearly establishes mediation as a condition precedent to arbitration, and this was set under parties' autonomy. Pursuant to Article 2, Subparagraph 3 of the New York Convention, the court referred the parties to arbitration unless the arbitration agreement is found to be invalid, unenforceable, or incapable of being executed. In the present case, that was a clearly provision that mediation was a condition precedent to arbitration, and claimants ignored that provision. This happened, members of the tribunal, in the case International Research versus Lufthansa. In that case, the Court of Appeals of Singapore understood that until the condition precedent to the commencement of arbitration is fulfilled, an arbitral tribunal would not have jurisdiction to hear the case.
Which was the applicable law in this?
The law applicable, Mr. President, was the Unilateral Arbitration and the International Arbitration Act from Singapore. So, members of this tribunal, this arbitral tribunal would not have jurisdiction to hear the case, as it was the intention of the parties to submit the dispute to mediation. And this can be proved by three facts. To demonstrate the first fact, I would like this arbitral tribunal to follow me on page 31 from the case file.
Before you go to the fact, sorry, one question. So you mentioned your convention and Article 2.3, and you mentioned invalidity, unenforceability, and incapable of being performed, the three categories. Which one of the three are you arguing in this discussion?
The arbitration agreement, Mr. Arbitrator, is invalid in the present case. And that's why this arbitral tribunal does not have jurisdiction to hear the case.
And it is invalid because it is a multi-tiered agreement?
Exactly, Mr. Arbitrator.
Okay, you may proceed.
So on the page 31 of the case files and page 33 of the PDF, this was an email sent by Mr. Damon, that is the head of contracting of claimant, and on the third line from the bottom of the page to the top, initiating with furthermore, I quote, "Furthermore, the FAI model mediation clause suggested by us clearly provides that the parties must first try to mediate their dispute before resorting to arbitration. Thus, arbitration is the last resort as you wished." Claimant proved here that their intention was to submit the dispute to mediation prior to arbitration. Moreover, members of this tribunal, the dispute resolution clause is claimant's own design, which reveals their double standards. Claimant suggested in the present case that the model law should be used as the FAI model law. However, the FAI model clause has an explicitly provision that I quote, "The commencement of proceedings under the mediation rules shall not prevent any party from commencing arbitration in accordance with the clause below." This is on the FAI model clause. However, claimant drafted the model clause in the present case and intentionally excluded that provision, which shows that claimant's intentions was to submit the dispute to arbitration only if the mediation proceedings occur. And in the present case, they completely ignored it. Moreover,
Sorry to interrupt again. Did the respondent commence mediation?
No, Mr. Arbitrator. The parties didn't commence mediation. That's exactly why this appellate tribunal would not have jurisdiction to hear the case, as mediation is a mandatory condition precedent.
But don't you think that by doing so, if your position is right, I'm not agreeing with you just for the sake of discussion. You said the parties should mediate, but you don't want to mediate. And you say the parties cannot go to arbitration. I don't think this outcome will prevent claimants from proceeding. Don't you think that's there should be a way for claimants to have a venue to discuss?
Mr. Arbitrator, in the present case, respondent wants to mediate, and this was on the dispute resolution clause, and not only respondent, but both of the parties, as who drafted the model clause was claimant. And it was claimant's duty to initiate the mediation proceedings. But claimant completely ignored that provision and presented a request for arbitration. And that's why this appellate tribunal would not have jurisdiction to hear the case.
But if I don't understand, because if you want to mediate, you just have to file a request for mediation.
Yes, Mr. Arbitrator, and this could be a provision. However, claimant ignored that provision and presented a request for arbitration. And that's why we are here today, because this appellate tribunal would not have jurisdiction to hear the case, as mediation was clearly a condition precedent.
We are only asking those questions because you quoted a provision that is omitted. In that provision, the premise is the commencement of mediation. That premise is non-existent in this case. Do you agree?
Yes.
Okay. You may proceed.
So, members of this tribunal, in the present case, Exhibit R3 should be maintained in the case file. As this appellate tribunal can follow me on page 32, where you can find Exhibit R3, the document that should be maintained in the case files. Exhibit R3.
33?
32, Mr. Exhibit R3 shows for this appellate tribunal claimants' unlawful conduct in the context of the negotiations, and that's why the document should be maintained in the case files. Members of this tribunal, fraudulent misrepresentation is a form of fraud in which the intentional misrepresentation of a fact induces another to enter in a contract. Pursuant to Article 3.2.5 from the Equatorian Civil Code, it may lead to the right to avoidance of the contract. On Exhibit R3, we can see that claimant acted in misrepresentation, and that's why the document is not protected by attorney-client privilege. On the fourth bullet in the middle of the page, I quote, "For the e-ammonia model, you had been in negotiations with P2G from Equatoriana, which originally looked very promising, but had remaining quality issues, and now the price speaks in favor of another supplier." With this, claimant showed in this email that the negotiations with the company P2G for the e-ammonia option was not a reality and could fail. However, if this appellate tribunal can follow me on a page back, on the page 31, page 33 from the PDF. It was an email sent 2 days after by claimant, in which on the third line to the top, on the top of the page to the bottom, initiating with, I quote, "We had a very good discussion with them and were initially impressed by their proficiency and production facilities. While the facilities would definitely need some upgrades and some additional training, we are confident that we may be able to overcome the present quality issues. In that case, we would most likely even arrive at a local content of around 45%. With this, members of this tribunal, we see that what claimant said to respondent was not the reality. The negotiations with P2G would most likely fail, as it is presented on Exhibit R3. However, claimant furnish informations that do not match in the present case. So Exhibit R3 is a document that is related to fraudulent misrepresentation. It's a document that shows for this appeal tribunal that they are acting unlawfully in the context of the negotiations. And that's why the document is not protected by attorney-client privilege, as claimant would present.
I have a question on that. Which is the applicable law to ascertain whether or not it's an exception to attorney-client privilege?
Ms. Arbitrator, the applicable law in the present case is Equatorian law. Most jurisdictions, such as Singapore, United States, and England, that are common law jurisdictions, such as Equatoriana, does not protect communications from privilege that are related to crime or fraud. And in the present case, the Exhibit R3 refers to fraudulent misrepresentation. Moreover, members of this tribunal, Exhibit C7 should be excluded from the case files because it is protected by settlement privilege. Exhibit C7.
How did you get this document R3?
They're not explicitly information, Mr. Arbitrator, in the case files related to that question.
Would you agree that if we find there are suspicions that it was obtained in a illegal way, then your argument will be used against you, like about illegality prevents it's an exception? Like if its document was obtained in an illegal way or unauthorized way, then this document cannot be used.
Mr. Arbitrator, I see my time is finished.
Okay.
Can I ask 3 more minutes for this after tribunal?
Sure.
Okay. So, Mr. Arbitrator, concerning your question about the illegality of the document, even if this after tribunal declares that the document was illegally obtained, the document is still relevant in the present case because it can show claimants unlawfully conduct in the context of the negotiations. And this happened.
So we can use unlawful ways to prove an illegality. Is that your position?
No, Mr.
I'm not prejudging, I'm just thinking the realm of ideas.
In the present case, Mr. Arbitrator, it's not proved that. And in the case Cardinal Holdings, the tribunal decided that where there is a chance of the evidence be illegally acquired, the evidence cannot be excluded. So here, as it's not proved, it cannot be excluded. In any event, Exhibit C7 should be maintained in the case files as it is protected by privilege. Exhibit C7 refers to any mail that refers to an offer that explicitly says that it's a without prejudice offer. And because of that, the document is protected by settlement privilege, as is what it was a document which was labeled without prejudice, and the intention of respondent with that document was finding an amicable solution for the case. So because of that, Exhibit C7 is protected by settlement privilege.
Based on what? What's the basis for that?
The basis are the 2 requisites for a document to be protected by settlement privilege that are, firstly, the document should be labeled without prejudice, and secondly, it should refer to an amicable solution.
But that's based on which law?
This is based in a doctrine of Mr. O'Malley, where he finds out that the requisites for a document to be protected by settlement privilege are both of them.
Is that any local? Was it based on any local law?
These requirements?
Yeah.
The requirements are not based specifically in a local law, but can be generally accepted that are from common law jurisdictions, such as Equatoriana. So, members of this tribunal, with that, I resubmit my claims and thank this appeal tribunal.
Any question for Paula? Go ahead.
Thank you, Mr. President. No questions at this moment. Thank you.
Okay. Thank you. So now the floor belongs to claimant. We gave 2 minutes to respond, so have 16 minutes without extension. Because they were like, they were sharp in there. So I ask you to restrain to 16. You have 2 minutes more, but not more than that, please.
So once again, good afternoon, members of the arbitral tribunal. We are only here in this present dispute since respondent chose to terminate the agreement and did not try to enter in further amicable settlements using now arbitration or mediation as a bar for arbitration. In this sense, claimant has two main submissions, which is first, the tribunal has jurisdiction to hear the present dispute, that the claim is admissible, and second, that Exhibit R3 should be excluded from this arbitration, while Exhibit C7 should be admitted. Moving to the first point here, it is relevant to emphasize that the arbitration agreement actually fulfills all the requirements for its validity under the Danubian Arbitration Law, Article 7, being conducted between parties who are capable parties and conducting in writing. So all the formal requirements for its validity are fulfilled. And first, here it is relevant to emphasize that this is actually an issue of admissibility and not jurisdiction, unlike respondent like to portray. While admissibility concerns whether a claim is procedurally ready for resolution, jurisdiction, on the other hand, is whether the capacity of the tribunal to hear a case. And members of this arbitral tribunal, non-compliance with pre-arbitral steps, such as mediation, concerns issues of admissibility and not jurisdiction. And this was exactly the rationale that was applied in the SL Mining versus Sierra Leone case, where the High Court of England and Wales held that non-compliance with pre-arbitral steps, such as mediation, concerns issues of admissibility and not jurisdiction. And exactly for this reason, in the present case here, the mediation requirement is better understood as a procedural guideline rather than a jurisdictional barrier. And exactly for this reason, since the arbitration agreement fulfills the requirements for its validity, and this is an issue of admissibility, this tribunal has jurisdiction to hear the present dispute. Now, moving to the second point by the respondent, which is that the tribunal cannot admit the claim and does not have jurisdiction, as the mediation requirement is a condition precedent for arbitration. And to establish that the clause is a condition precedent, respondent brought two criteria, which is first, that the claimant excluded the one provision that showed that the mediation was not a mandatory precondition. However, members of the arbitral tribunal, which we can clearly see in Article 11 of the FII arbitration rules, is stated, and I quote, that an agreement on the FII mediation does not constitute any bar to any judicial, arbitral, or similar proceedings. So it's clear here that the mere exclusion of those provisions of the model clause does not impact that the mediation cannot bar arbitration. And this is specifically relevant here when we analyze respondent's conduct. The tribunal could follow me to page 53 of the case files and sign me when you're there.
Page?
52.
Go ahead. Which item?
On clarification number 14, it reads, and I quote, did the respondent ever request mediation or indicate that it would be inclined to participate in mediation as it applies to these issues? And the answer is no. There was no specific request after the dispute had arisen and before the request for arbitration had been submitted. You should be able to follow me now to page 55 of the case files. In clarification number 14, we can read, how did claimant respond to the without prejudice offer? Claimant rejected that offer on the next day and threatened to initiate arbitration proceedings should respondent not engage in further discussions with any preconditions. There was no further response from respondent to the letter. So it's clear here that respondent states that mediation was in fact intended and obligatory between the parties. However, respondent itself never showed a willingness to mediate. Quite to the contrary, the respondent actually showed that he was not willing to pursue any amicable settlement, which led my client to the only reasonable approach, which is to finally settle this dispute arbitration following the exact language of the contract.
And also, is that a waiver? No further response. Is that a waiver from respondent?
Not at all, Mr. Arbitrator. However, what we can see here is that since respondent showed I do not want for pursuing this mediation without a need for a litigious dispute would have been innocuous, since it showed that mediation would in fact be futile, as it never showed claimant that he was willing to pursue a mediation proceeding.
But how can you know that will be futile if you didn't have the mediation? Because what you can see here, that the parties have different positions, okay, but that doesn't mean that they will never settle. The mediator is someone with tools and skills that put the party together. So we wonder whether if the agreement was followed, the parties could have settled. Don't you think that's a case for the arbitration to be suspended and you go to mediation right now?
Actually, Mr. Arbitrators, mediation in another scenario would be a perfect solution for this dispute. However, what we have to analyze here is that respondent not only prior to this arbitration never showed any attempt to resolve this dispute, but also during this arbitration, as pointed by this arbitral tribunal, never point a request for mediation. So what claimant contends here is that initiating a mediation proceeding now is only respondent's tentative to bar arbitral proceedings and deny claimant from the rightful performance of its rights under the PSA. And exactly for this reason here is why this arbitral tribunal must in fact determine that the non-compliance with the mediation clause does not constitute a condition precedent to arbitration. Because for a clause to in fact qualify as a condition precedent, there needs to have a specificity on this clause. And we can see on the arbitration, on the mediation clause, that the clause does not have any enforceable deadlines, mandatory sessions, or explicit language bearing arbitration until the mediation is fulfilled, stating that mediation is in fact a condition precedent. So contrary to respondent's assertions, parties never chose mediation to be an obligatory precondition. It was a mere possibility for the parties to pursue mediation, which respondent itself showed to be innocuous.
I'm trying to understand this argument because the clause says that there shall be mediation, so there's a contract obligation. You have different qualifications, but it's generally accepted that it was an obligation. You are saying that the obligation was not followed, but there's no legal consequence. Is that your position?
Yes, Mr. Arbitrator, because there was no a mandatory obligation. There was not an obligation for the parties that mediation was in fact a necessary step and mandatory step. It was actually the first step for this dispute that showed that was not sufficient for this dispute. So my client here only took the only reasonable approach to follow the final language of the contract and settle this dispute through arbitration. And exactly for this reason here is why this arbitration tribunal must determine that it has jurisdiction to hear the present dispute, that the claim is admissible. With that in mind, respondent claimant will now move to its second submission and demonstrate that Exhibit R3 should be excluded from these proceedings, while Exhibit C7 should be admitted. In this regard, respondent stated that the Exhibit R3 should not be admitted, should be admitted due to demonstrates claimant's misrepresentation to the document. However, members of this arbitration tribunal, first here we have to take a step back and analyze what is the applicable law to these issues. And as stated by respondent, the applicable law, it is the Ecuadorian law. So you're going to follow me to page 55 of the case files. This is the procedure order number 2, and in clarification number 29, we can read, and I quote, "Do communications by in-house lawyer containing legal advice benefit from the attorney-client privilege under the law of Equatoriana?" And the answer is yes, at least if the in-house lawyer is at the same time a member of the bar and the advice was given in relation to a specific legal question relevant. So it's clear that the own law that the respondent chooses to apply to these issues, which is the law applicable to this present case, actually protects relationship between a client and its in-house counsel, which is precisely the context of Exhibit R3, which is an email sent by claimant's in-house counsel to claimant's CEO. And respondent tried to allege that this document represents a misrepresentation of claimant is actually unfounded, because here claimant actually was worried on its email that it would not fulfill the requirements. So it was actually seeking a legal advice to its lawyer to make sure that all the requirements to make the right performance of the contract be complied with. So here we can see that both this does not constitute any misrepresentation from my client, and this email actually concerns a protected by attorney-client privilege under the law of Equatoriana, which is the law applicable to the present case. And exactly for this reason here, we must analyze that this document cannot be admitted to arbitration because it's an internal email that no one knows how respondent acquired this email, and it actually is protected under the applicable law, not containing any misrepresentation.
But how could they prove? Let's assume it's good that you agreed on applicable law, and also you agreed on the content of the applicable law. The only thing that you disagree is there is one qualification. You said that since this is not, if I understood it correctly, since the document contains no misrepresentation, it will not fall into the exception. And the question that I'm making, how could respondent prove the misrepresentation without this document? I don't think that this document is the only way for a respondent to prove the misrepresentation, like without getting internal documents from for claimant, it would be impossible to show that claimant knew that the declaration that was contained in the agreement was false.
Which arbitrator, your answer is twofold. First, even if we were to analyze the materiality of the document, we can see that does not prove any misrepresentation from my client, since it actually proves that it was interest on getting to resolve the problems regarding the future use required. And it actually shows that this document would have been fulfilled all the requirements under the local content percentage that required for the document. However, even if this tribunal decides that this document is in fact not material to this dispute, we must analyze that this document is protected under attorney-client privilege under the Equatorian law. And exactly for this reason here, this tribunal must not admit this document. Now regarding Exhibit C7, which is a without prejudice offer sent by respondent to claimant, respondent brought that this document is protected by the settlement privilege, and exactly for this reason, it cannot be admitted into this arbitration. However, members of this arbitral tribunal, respondent does not bring any legal grounds to apply this type of privilege. And if you are to analyze under both possible legal applicable jurisdictions here, we can see that none of these jurisdictions have any provisions regarding this type of privilege. It actually is not protected by any applicable law here. But even if we were to apply this type of privilege here, it is clear that the without prejudice privilege only applies when a document shows a real tentative of resolving disputes. And actually, Exhibit C7 does not show this position, as it is an ultimatum sent by the respondent that it would only pursue with these negotiations if claimant already perform a reasonable price reduction on its contract. So it's quite convenient that respondent now wants to exclude the only document that proves that it was not willing to pursue a mediation. And exactly for this reason here is that the arbitral tribunal must exclude Exhibit C7. With that in mind, claimant now reinforces its submissions. Thank you.
Counsel, again, what's the applicable law to this discussion on the C7?
Mr. Arbitrator, there is no law applicable to without prejudice privilege in the present case. So we must analyze that this document is admitted as it is in fact material to this dispute under Article 34(1) of the FII arbitration rules, which determine that this tribunal must analyze the materiality of the document. And in fact, this document is material to this dispute, as it is not protected by any privilege under any of the legal jurisdictions applicable. Thank you.
I'm not quite sure I follow your argument. Is there an applicable law to this debate? Because for R3, you mentioned there is an applicable law, right?
Yes.
Equatoriana.
Yes.
And C7?
If we apply the law of Equatoriana to an analysis document, we can see that under Equatoriana law, there is no provision regarding without prejudice privilege. So under the applicable law here, there is no provision protecting this document.
Because I heard respondent alleging responding to my co-arbitrator, the president, you mentioned that the applicable law was common law jurisdiction Equatoriana for this discussion. You agree with that?
Yes, Mr. Arbitrator.
But you're saying that there is no specific provision for privilege in that regard.
Perfect, Mr. Arbitrator. Claimant reinforces its submission. Thank you.
Thank you. Professor Paula, do you have any question?
No further questions, Mr. President. Thank you.
Respondent has 1 minute for rebuttal.
Members of this tribunal, claimants argue that mediation would be fruitless because respondent was supposedly unwilling to negotiate. However, it's not because the negotiations after the termination of the agreement did not succeed that with mediation would be the same. A mediation proceedings is a formal proceedings that includes a mediator, a specialized person who is there to help parties engage in discussions and in negotiations. Due to that, members of this tribunal, claimants' arguments of skipping that important step in the present proceedings does not have any legal basis. There's not a point of including a multi-tiered dispute resolution clause if it's not going to be respected. Thank you. Members of this arbitral tribunal, a claimant actually agrees that mediation is in fact a good proceeding resolution. However, when we analyze parties' conduct here, we can see that respondent was never willing to mediate and actually closed doors to mediation. So exactly for this reason here, that the only reasonable result of this dispute is to litigious proceedings. Thank you.
Thank you. Any questions from arbitrators? So let's move to the merits. Now, Ms. Correa, the floor is yours for 14 minutes.
Good afternoon, members of the tribunal, my opposing counsels. My name is Mariana Carreira, and in the following minutes, I will be addressing claimant submissions on the merits of the dispute. Before beginning, it's important to briefly recapitulate some of the facts of this case. The Purchase and Service Agreement, the PSA, stems from respondents' governmental public tender process to integrate a green hydrogen plant into Equatoriana's green energy strategy. After claimant demonstrated that it would comply with respondents' requirements, it won the award and became tasked with the delivery of the plant. Then, respondent unilaterally terminated the contract and led claimant to initiate this arbitration and request the CSG to be applicable to the PSA, a position respondent contests. Therefore, claimant will demonstrate on the merits, first, that the CSG is applicable to the PSA, and second, that the parties have never validly excluded the application of the convention under its own terms. Regarding my first point, there are 3 reasons why the CSG is applicable to the PSA. 1, it is an international contract. 2, it is a mixed contract with a preponderant delivery aspect. And 3, it is not the result of a sale made by auction and is thus not governed by the exclusion under Article 2B. Moving to my first point. Respondent argues in its answer to the request for arbitration that the CSG is inapplicable to the PSA under its Article 111 because parties supposedly have places of business in different contracting states. However, this is inaccurate. Even if there is no precise definition of what a place of business under the convention is, a very accepted definition, according to Professor Pascal Hacking, is that it is the place where the party continuously and independently engages in trade. And this has to be established during contractual negotiations. And in this arbitration, claimants, both parties are contracting states of the CISG. Additionally, claimant's administrative center is in Mediterranean. It is in Mediterranean that claimants continuously and independently engages in trade and makes all relevant decisions, including the ones that led to the PSA. And it is for this reason that the contract is international and the convention is applicable to the PSA under its Article 11A. Now, moving to point number 2 of my submissions. It is respondent's assertion, also in its answer to the request for arbitration, that the PSA is supposedly a service agreement, and therefore the convention would be inapplicable to the PSA under its Article 3.2. However, this is also inaccurate. The PSA is, as claimant will demonstrate, in fact, a mixed contract with a preponderant delivery aspect, which makes the CISG applicable under its Article 3.2. To determine if the CISG is applicable to a mixed contract, one must determine what the preponderant part of this contract is. And to do this, according to the CISG Advisory Council Opinion number 4, you have to perform an overall assessment of the case and regard the weight given by the parties to each obligation. And to perform this overall assessment, the primary criteria and the most important criteria to apply is the economic value criteria, which looks at the financial weight each obligation holds. And if there is enough data in the case to establish that the delivery of goods had a larger financial weight than the services, then the delivery is preponderant and the CISG is applicable regardless of the extensiveness of the services provided. And this was the exact ruling in the pizzeria equipment case by the District Court of Munich in 2004. To illustrate my point in this arbitration, I would like to ask the tribunal to follow me, please, to page 17 of the case files, which is Mr. Cavendish, claimant CEO's witness statement. Let me know when you're there. So just below paragraph 11, we have a spreadsheet provided by claimant to respondent containing the initial calculations for the project. In the electrolyzer portion, you can see that the goods portion of this part are the core system and the traffical and electrical equipment, which are the 2 first lines. In the ratio column, you can see that 50% of the core system and 20% of the traffical and electrical equipment, that these parts represent 70% of the total investment in the electrolyzer. Now, in the EPC work section, you see that and the first line is also referencing goods: compressor, pipes, cable installation, connections, and other equipment. In the ratio column, you see that this amounts to 50% of the total investment in the EPC work section. Therefore, it's very clear that the largest amount of financial capital that was going to be invested by the parties was allocated to goods, which already makes the goods preponderant. But to further illustrate this, I would now ask the tribunal to divert its attention.
Second, Costa, sorry, just in this document still. Buildings and foundations, service or goods?
Services.
Okay, so 50-50?
In the EPC work section, yes, but in the total investment, no. The total investment, in fact, if you make all the calculations in the spreadsheet, 63% allocated to goods, and the rest is allocated to services.
You're getting the 70 and the 50. The 70% and then the 50?
Yes.
And then 63.
Yes.
Okay.
Now, I would like the tribunal to divert its attention to page 11 of the case files, please, which is in the PSA. So Article 7, just at the bottom of the page, is the article relating to the remuneration structure of the contract. It reads, and I quote, "For the delivery of the plant and the additional maintenance and training services, the contractor is entitled to an overall remuneration of, here it reads 95 million, but the contract price was later on corrected. But the point here is, respondent as a buyer was paying for the delivery of the plant. This was the good that was being sold to respondent. Equally, claimant was delivering the plant and being paid for this delivery, and transferring the title of and transferring the ownership of the property. And this constitutes typical sale obligations, which makes the CSG applicable to the case under its Article 3.2, as it is clear that the preponderant part of the agreement is, in fact, the delivery of goods.
Counsel, but if you see even the title here, purchase and service agreement, if you go to scope, Article 2, scope of supplies and service. So we are getting just like one clause. If you see other clause, we give like equal weight for this.
Mr. Arbitrator, the clauses don't give equal weight to the obligations. Claimant doesn't deny that there is a service component here, and this is why it is a mixed contract. But mixed contracts are governed by the convention under Article 3.2, and it's very clear from the remuneration aspect that as a buyer, respondent was buying the plant. The maintenance and training services were merely additional, and as a seller, claimant was selling the plant, which makes the CSG applicable. Now, moving to point number 2 of my submissions on the applicability of the CSG. In its answer to the request for arbitration, respondent affirmed that the convention should not be applied to the PSA under Article 2B, as it is supposedly the award of a sale made by auction. In this sense, an auction is a sale open to the public in which there are multiple buyers and one seller, and the award goes to the highest bid. According to the Secretariat commentary of the drafters of the convention, auctions are excluded from the convention scope because they have a typically localized nature, and the parties don't know each other, which makes the application of the convention dubious, since one could be taken by surprise with the applicability of the CSG. However, members of the tribunal, the PSA stems from a reverse auction process. A reverse auction has multiple sellers and one buyer, and the award goes to the lowest bid. And more importantly, when there is a governmental public tender process in which the reverse auction is a step, the international openness of the project, the defined parties, and the structure process makes the exclusion under Article 2B inapplicable. And this was the exact ruling in the electronic electricity meters case by the Swiss Federal Supreme Court. What we have here is a reverse auction process. Respondent knew that there was no local entity that would meet its requirements, and thus made the process internationally open. Additionally, respondent knew all of the parties, and all of the parties knew respondent. So respondent at no point could have been taken by surprise by the application of the CSG, which makes the exclusion under Article 2B entirely meaningless in this case. And thus, the CSG remains applicable to the PSA, precisely because the exclusion under Article 2B does not apply. And now, having demonstrated that the CSG is applicable to the PSA, claimant will also demonstrate that despite respondent's arguments to the contrary, the parties have never validly excluded the application of the convention under its own terms. Under Article 6 of the CSG, parties from contracting states can exclude the application of the convention, whether implicitly or explicitly. In this arbitration, it's undisputed that there was no explicit exclusion of the convention. For an implicit exclusion to be valid, there has to be a clear and unequivocal agreement between the parties to this extent. And to analyze this clear and unequivocal intent, in Bruno and Gottlieb's commentary on the CSG, Professor Schmidt and Dr. Manner established 2 cumulative criteria to assess this clear intention. First, there has to be a sufficiently clear intent of both parties that they want the CSG to be excluded. And second, there have to be concrete indications that the parties intended to have their legal relationship be governed by a specific set of domestic rules, knowing that the CSG would in principle be applicable to the contract. Otherwise, absent any of these criteria, the CSG is automatically applicable to the case under the Convention's default rule of application. And members of the tribunal, in the present case, none of these criteria have been met. First, the parties never properly discussed the applicable law to the PSA. The negotiations were entirely incomplete. And even if we concede that respondents' intention to exclude the CSG was clear, claimants never was. There was no meeting of minds to be found in this case. And second, Article 29 of the PSA is not an exclusion of the CSG. This is because Equatoriana is a contracting state of the Convention. Therefore, the CSG is part of Equatoriana law. Respondent, if it wished the Convention to be excluded, had the burden of writing a concrete clause that indicated unanimously that it wanted the CSG to be excluded, and it did no such thing. Article 29 does not constitute a valid exclusion of the Convention. And since the parties have no clear agreement, and since there is no common intent to exclude the Convention, the CSG is automatically applicable to this case under its default rule of application. And with that, claimant reinforces its submissions. Thank you.
I have a question on this last point. I'll not go into your very well done submission on whether or not a CSG is part of Equatorian law or part of the conflict of law principles. Let's assume that you're right. But anyway, the way it's written here, you know, that the agreement of the party sometimes are not well written from a legal standpoint, but still it reflects the agreement of the parties. And here, instead of a standard, the CSG will apply. It's written here, it's agreement governed by the law of Equatoriana. So they're referring to the law of Equatoriana. And they're excluding conflict of laws. So even assuming that from a legally technical standpoint, you're right, maybe the will of the party was to apply Equatoriana civil code, because why would they write governed by the law of Equatoriana with exclusion of conflict of law if they want CSG? Why not just saying CSG will apply? How would you interpret the reason why the parties changed the governing law to something that might not be technically an exclusion of CSG, but might be an evidence that they wanted the exclusion and might not have done that in the proper way, but we are looking here for the will of the parties. Please explain me why do you think this change to this wording is not an exclusion?
Mr. Arbitrator, seeing that my time is running out.
That's on me.
Well, first, the intent to exclude the Convention has to come from both parties. Otherwise, the exclusion cannot be valid. And even if respondent had an intention to exclude the CSG, it had the duty of knowing that the way it wrote Article 29 in the PSA does not constitute an exclusion. And even if we concede to respondent's intention, to the clearness of respondent's intention, the actual communication between the parties cannot constitute, does not lay ground for a valid exclusion to have been made. To illustrate this, please follow me to page 30 of the case files, which is Ms. Joanna Ritter's respondent's head of contracting witness statement in paragraph 11. In paragraph 11, Ms. Joanna Ritter describes how the negotiations on the applicable law went. After stating explicitly that the issue was never really addressed, in line 6, starting with as neither, it reads, and I quote, as neither Mr. Cavendish, claimant CEO, nor Ms. Faraday, respondent's negotiator, are lawyers, it was agreed that the issue should be left to the lawyers for discussion. The parties never discussed the application or non-application of the CSG, and respondent had to have known that simply mentioning Equatoriana law and not mentioning the CSG does not legally and technically constitute an exclusion. And if its true intent was for the exclusion to be valid, that there had to have been clear and proper discussion between the parties, and this never happened. So the exclusion can't be valid. Thank you. And with that, I reinforce my submissions.
Any question? Professor Paula, do you have any question?
Thank you, Mr. President. No further questions.
Okay, so I use 2 minutes more from claimant's time. Thank you for being sharp on the time. The time extension was mine. But anyway, I'll give you 2 more minutes, so we have 16 minutes.
Thank you. Members of this tribunal, on the merits of this case, respondent opened a tender process, an auction process, for the construction of a green hydrogen plant. Respondent chose claimant, awarded the project to claimant because claimant guaranteed that in a short period of time, the plant would be concluded. Claimant then reaches its first deadline established by the parties, and not only that, but also breaches all the its main obligations under such deadline. This showed to respondent that claimant was an unreliable business partner. And now, claimant attempts to make respondent's termination unlawful by attempting to apply the CSG to an EPC contract. This claim does not stand, and that is why, contrary to claimant's submissions, first, the CSG is not applicable to the present agreement, and second, that the parties have validly excluded the CSG from the present agreement. Entering now respondent's first submission, it is claimant's contention that the CSG would apply due to 3 main reasons. The first, the internationality of the present agreement. The second, the preponderance. And third, because it was not a sale by auction. Respondent will just change the order and first address the preponderance of the agreement, then the internationality of the present agreement, which is not evident, and second, that this in fact is a sale by auction. Regarding respondent's first argument, under Article 3.2 of the CSG, to determine the preponderance of a mixed contract, the intention of the parties and the formation of the contract must be taken into account. This, according to CSG's Advisory Council Opinion number 4. And it is correctly stated by claimant that to determine preponderance, there is the first main criteria, the primary criteria that should be applied, which is the economic criterion. And if the tribunal finds that the economic criterion is not possible to assess whether the preponderance of goods would be the sale of goods or service, then we must turn subsidiarily to the essentiality of the goods criterion, in which to determine what the weight of the parties gave to each obligation to determine preponderance. In the present case, it is not evident by the economic criterion that the CISG would apply that the preponderance of this case would be the supply of goods. Claimant has shown this arbitral tribunal the internal calculations of claimant to determine the main agreement. It was on page 17. If the arbitral tribunal could please follow me to page 17, this table.
Mm-hmm.
The table shown by claimant is not enough to determine the preponderance of the present agreement, because claimant ignored that in the present agreement, there was an e-ammonia option to be as extension of the power plant. And with the e-ammonia option, 100 million euros more would contain for the total of this agreement. And therefore, in this table, only calculates the difference of supply of goods and service for the main agreement, which was just the green hydrogen plant. So it's not enough from this table alone to determine the preponderance of this agreement, because with 100 million euros more to the total of the contract. And in the e-ammonia option, there is no clear intention from the parties that whether the part of it would be the supply of goods and what would be the supply of service. This table is not applicable to determine the preponderance. Not only that, respondent has also shown this arbitral tribunal to the lump sum total in the agreement. And if the tribunal could please follow me to that page, which is page 11 of the agreement, on Article 7. It is evident in the agreement that by the agreement alone, there was no separation by the parties of what would be the cost for the supply of goods and the cost for the supply of service. This is not clear from the agreement. It is only a lump sum total to be paid by a respondent in the present case. So the economic criterion in the present case is not applicable. It is not clear from this criteria. So then we must turn to the essentiality of the goods criterion, since the economic criterion is not a valid way to determine in the present agreement. By the essentiality of the goods criterion, one must assess, as stated by claimant, that what the weight of the parties gave to those obligations, the obligations of service and the obligations of goods. It is very clear from this agreement that the parties gave weight to the service, to the engineering, the construction, and the procurement of a plant. A plant is also not a good. It is claimant's contention that because there was, in the present case, the delivery of a plant, that this would therefore make it essential, since the good would be the plant. And this is not the case. A plant cannot be a good. First, because a good needs to be movable. And second, because it cannot be permanently stayed in the ground. And this is the same understanding as Professor Ben Kohler. Therefore, the plant cannot be a good in the present case. Thus,
So, do you have case law?
Case law
for that?
to determine that they need to be movable.
To give more weight to engineering services, as you mentioned, in this type of contract?
That to the turnkey. I don't have a case law with me right now, but it is a general understanding that turnkey contracts would not fall within the CSG's application by default. And this is the present case in the case files. In the agreements, there is no mention to the supply of electrolyzers. There is no mention to the supply of transformer. Actually, the sole mention to electrolyzers was in the whereas clause. And in any other place in this agreement, there was a mention of electrolyzers. So it is not the preponderance of this agreement, the sale of goods, but of service. Now turning to the internationality of the present agreement. The present agreement is a domestic in the sense of the CSG. Under Article 1.1, to determine the internationality of a contract, one must look at whether the parties have different places of business. Places of business is defined as where the party conducts trade regularly with a certain stability. And this is also the understanding of Professor Pascal Hacken. In the present case, claimant has ignored the involvement of Volta Transformer, which is an Ecuadorian company, to the present case. Volta Transformer is the place of business of claimant in this agreement. And this could be in a very similar case to the present one where this happened, is the Target Corp case versus the GSS Development Ltd, in which the court found that, and I quote, the Minnesota District Court of the United States, to accommodate Target's product volume, ERS, which is the other party, opened an Indianapolis facility and invested in substantial infrastructure for transport, inspection, repair, and repackaging, disassembly and recycling, rerouting, and disposal of TVs and other electronic products. The court concludes that the ERS place of business for the purpose of ERS's contracts with Target is in the United States, and therefore the CSG does not apply, end quote. In the present case, it is very similar. Claimant has acquired Volta Transformer for this contract to supply goods to this contract and to supply the transformer. And this is why for the place of business of claimant, it would be Equatoriana, not Mediterranean, for the purposes of the present PSA. Now turning to the third argument made by claimant, which is the auction, that this would not be a sale by auction. Claimant ignores the fact that not only the requirement for it to be applied as an auction, that the parties did not know of the internationality of the contract. It is not only that. The other reason behind the CSG's inclusion of auction is because there are widely different special rules existing in national legal systems to determine an auction. And this is what happens in the present case. In the request for quotation, the auction is governed by the public procurement law of Equatoriana. And therefore, there is many public procurement laws and very different in the world. In the present case, it would not be applicable the present auction because it would be because of this purpose. Thus, the CSG does not apply in the present case for those three main reasons. It is a sale by auction. It is the preponderant part of the agreement, the sale of service. It is the supply of service in the present case, since it is an EPC contract. And third, that it is not an international contract. Now turning to my second argument, my second submission. The parties have validly excluded the CSG's application in the present case. Claimant suggests that since there was an implicit exclusion of the CSG in the present case, this would render the CSG as applicable. This is not the case. There was, in fact, an implicit exclusion in the present case. This is because to determine what the intent of the parties, one must look at Article 8.1 of the CSG, in which it states that the conduct of a party are to be interpreted according to his intent, where the party knew or could not have been unaware what was the intent. And this, to determine the intent in the present case, we must look at the changes in the model contract that happened. In the previous model contract, which claimant knew of, there was an explicit inclusion of the CASG, and this model contract changed. And in the present case, which was what was based on the present agreement, there was an exclusion of this inclusion of the CASG. This renders that, and since claimant knew of this alteration, since it had worked with other contracts in that same sense, it is evident that claimant could not have been unknown of this requirement, of this change in a model contract. The parties are sophisticated parties. If claimant did not had any objection to the applicability or the not applicability of the CSG in the present case, respondent was open to assess, to negotiate this present clause. But claimant has never raised an issue towards this clause in the present case. And that is why
I have a question on that, counsel, because the argument from claimant is that CSG is part of Equatoriana law. And CSG is a treaty, is an applicable legislation, but it does not cover everything. So what she's saying, right or wrong, is that this clause is an improvement because it's Equatoriana law. CSG for whatever CSG applies, in Equatoriana law to the remainder because CSG does not cover everything. don't you think that's a reasonable interpretation? Like someone that reads this would think, oh, I'm not excluding CSG because it's not saying that excluding CSG is just having a more complete applicable law clause, and your client had to take into account that CSG is part of Equatoriana law. Because I think the main point here is that CSG is part of Equatoriana law, so in your line of thinking maybe assuming that it's not.
Yes, at a first look, it might look like this clause has stated that the CSG would be applicable because it is within Equatoriana's legal framework, and this is true. However, one must look at the intent of the parties and the behavior that the parties took at the negotiation of this contract. And it is evident from that the parties intended to exclude the CASG because claimant could not have been unaware that there was a change in the model contract that happened. If claimant was so adamant of including the CSG in the present case, it would have objected. It would have said anything to respondent that suggested that it did not agree, that it wanted to include the CSG in the present.
No, but claimant, there are two options here, like two reasons why, like receive a clause that's different, okay, but there are two justifications. There are justifications that they change it because they want to exclude CSG. And claimant's justification, that is, they change it because they want a better clause, and CSG is part of Equatoriana law, so nothing changes, just better written. Don't you think that's not conspicuous here, that they're excluding CSG?
In the present case, it will not be, because it is claimant's duty also to assess what the parties have intended. It is to assess the old model clause, to know of Equatoriana's legal framework. And it is evident in the present case that even though there was no explicit inclusion of the CASG in the present case, this is because the parties did not intend to do so. It intended to apply Equatorian law in the present case. And therefore, I thank this arbitral tribunal and resubmit my submissions. Thank you.
Thank you. Wow, perfect timing. Professor Paula, Rafael, any questions?
No further questions.
Professor Paula?
No further questions. Thank you.
Thank you. So now claimant has 1 minute.
Members of the tribunal, respondent very confidently states that the plant is not a good under the CSG, with no case law to support this assertion. However, in the spinning plant case, the Swiss Federal Supreme Court held that goods under the CSG are movable and tangible at the time of delivery, even if the finished product is immovable. And this was decided on a case involving an entire industrial plant that was held to the ground, and the CSG was ruled applicable under Article 3.2. Therefore, the same must be decided here, as the preponderant part of the agreement is the delivery of goods. Thank you.
So was that a turnkey lump sum?
Yes, it was a turnkey lump sum.
Ms. Mello?
Members of this tribunal, claimant ignores the backbone of what is a good in the CSG. For the CSG, a good is a tangible, movable object. Even though in these walls, the glass, the bricks, the wires are goods, that does not mean that the whole building is good. This is irrational. It is a 5-kilometer plant. This is not a good in the sense of the CASG. Thank you so much.
Thank you. So now have a short break that will deliberate. But if you're watching us, wait 5 minutes. It's going to be or 10. Going to be back soon. We'd like to thank a lot both parties, the counselors, for the excellent job, and wait a little bit.
Thank you very much.
Professor Paula, just a quick adjustment. Could you please kindly enter into the deliberation room link, and then Joaquim and Rafael will join you in the next room. The things can remain here. Okay, thank you.
Is it the first link you send me?
Yeah.
Thank you. Thank you.
Yeah.
So we're back. First of all, on behalf of Souto Correa Advogados, I would like to thank all the participants once again, all the Moody's, all the arbitrators who have been involved in this during this weekend in this Souto Correa Pre-Moot. We are fully aware that this is the first Pre-Moot in Brazil for the teams. Nevertheless, we were very impressed overall by both teams here, by the quality of their arguments, by the quality of the delivery of the presentation. So congratulations to everyone involved in the finals. Without further ado, I will announce now the winner, and the winner is PUC São Paulo. Congratulations. So this is the end of our transmission. Thank you for all the viewers. Thank you, Professor Paula, for your participation remotely. Thank you, Joaquim, for your participation as well.